Kia ora, welcome everyone. My name's Alan Crome. I'm the Director of New Zealand Shores and Licensed Immigration Advisor. Yeah, it's really quite timely that we have this webinar. It's been almost 2 years, funnily enough, since the accreditation system came into place, and everyone's coming up for renewals really quite soon. So there's a bunch of stuff that we need to cover off. Just so we can commence, I would like to introduce everyone to on the panel here today. We're really fortunate to have Immigration New Zealand join us. They've been fantastic support to us for quite some time now, and really appreciate your presence. So we've got the engagement partners from Immigration New Zealand. We've got Lauren Burton, and we've also got Paul Miller who join us. So welcome, Lauren and Paul. Thank you for your time. We've also got Sylvie Thrush-Marsh. Now MyHR, an awesome partner of ours, and have been for quite some time now, many years. And Sylvie is the Chief Evangelist for MyHR, and they've got an amazing presence in the HR space and employment law. So highly recommend their services. Sylvie will be covering off some of those topics today as well. And we've got also Fabian Maisonneuve and Charlotte Stockman. They are two of our most senior licensed advisors, and also part of our management team. So you'll hear from them later on today as well. So just a little bit about the agenda. It's going to last for an hour. Make sure it doesn't go over an hour, and appreciate everyone's time. And it's quite it's obviously everyone's busy, and so we'll keep this to an hour. It'll start off with Immigration New Zealand. They will cover off a lot of the changes that we've seen really in the last 2 years, but more recently in the last 6 to 7 months with the skilled migrant changes and the accredited employer work changes. And last month, what that means for a lot of the skills and what it means to your workforce. So they'll cover off a presentation there, and then it will lead into Sylvie, and she'll cover off employment law and HR, and some of the implications that relates to with immigration. We'll finish off with Fabian and Charlotte, and then we'll have an open Q&A. One thing I can mention is it may not be possible to get through all of your questions, but I do encourage everyone to place their questions using the Q&A link within Zoom. And if we don't get them to them today, we'll certainly respond in full by the end of tomorrow and circulate that back to everyone. So please do use that system. If we can cover it today and we've got time, we certainly will do so. So yeah, okay, again, thanks for your time, everyone. I'm going to now pass over to Lauren and Paul, sorry, to take us through the immigration presentation.
Thank you. While we're just waiting for the slides to come up, I will start us off. So kia ora koutou, and thank you all so much for being here, for inviting me to come along and present. I'm sure my face will not be new to a lot of you, but maybe. I'm an engagement partner here at Immigration New Zealand, and so is my colleague Paul Miller, and we deal with immigration stakeholders such as yourselves at a strategic level through such things as webinars and events with industry bodies like this. So Paul will jump on a bit later on, but I'm going to take us through the more complex sort of bulk of the webinar. Just a reminder before we get going, we do engage at a strategic level. We work across the system, so we are generalists rather than subject matter experts. We are your conduits to the subject matter experts so they can focus on the important work that they do, such as policy. All right, so we'll run you through the agenda. Next slide, please. So just a very brief agenda here. High-level overview of recent changes. As you'll all be aware, the Minister has made some announcements regarding a whole raft of changes. We're going to go through some of those. Deeper dive into maximum continuous stay, visa duration, applications, and reusing tokens. We'll have some fantastic scenarios for you all to think about and work through how that may apply to you and your business. And of course, renewing employer accreditation. We know that's front of mind for most of you, so we'll come to that at the end of the presentation. All right, so just a high-level overview of recent changes we have here on screen, just a few of them that are the most important. So we'll just linger here for a moment. We know that you may have questions about the reasons or the rationale for these changes. We cannot speak for the government, but Minister Stanford has made a press release about the changes, and you can find this on the releases section of the Beehive website. So the changes include reducing visa duration and maximum continuous stay for some visa holders. As you may or may not be aware, new English language requirements and new minimum skills and work experience threshold. Other changes may include closing some of those work to residence pathways for bus and truck drivers and some additional obligations on employers. Next slide, please. Fantastic. All right, so the Immigration Employment Infringement Scheme, we just thought we'd touch on this just briefly. So we have a few changes that have occurred or that have taken place in the Immigration Act 2009. There have been three main changes that applies to everyone. So a new power to allow immigration officers to require certain employers to supply employment-related documents to an immigration officer immediately, or if not practical, within 10 working days. Secondly, creation of a new regime for employment infringement offences to target non-compliant behaviour that breaches the Immigration Act 2009, but does not rise to the level of serious offending. And thirdly, enable the Chief Executive of MB to publish names and offending related details of employers convicted of immigration offences or issued with infringement notices. So just drawing your attention to that. And we'll go over it a little further in the next slide. So the Immigration Employment Infringement Scheme. Under this scheme, employers who are found to be in breach of the law can be fined a minimum of $1,000, lose their accredited employer or RSC recognized seasonal employer status, and can be placed on the public standing face down list. Simply put, infringements can be issued for employing people in breach of their visa conditions, of course, employing a person unlawfully in New Zealand, or failing to comply with our 10-day document request, as I just mentioned before. As you can see, each offence carries a different fee, depending on whether an employer is an individual or a body corp or entity. Regarding the stand-down periods that you can see there, if you are an accredited employer, your accreditation will be revoked and you'll be put on the public stand-down list. After your stand-down period has finished, employers will have to reapply, of course, for accreditation if that's something that they choose to do. If you are not an accredited employer, you'll be placed on the public stand-down list anyway and will not be granted accreditation during this time. And of course, if you're an employer, you will not be able to hire any migrants on any other type of work visa that ties an employee to you, such as the specific purpose work visa. So just a very brief touch on those areas. And of course, we are happy to provide you with more information on that if needed. Just diving into the next section, we have some relative complexities here. So don't feel like you have to sort of frantically note everything down. We're being recorded. So, right, let's dive into it. Maximum continuous stay, visa duration, balances. We're going to go through all of it with some fantastic scenarios. We'll give you a reminder first about what has actually changed to help you understand the scenarios that we will go through. To define maximum continuous, sometimes, it's the total time that someone can stay in New Zealand continuously on one or more AEWVs, so that's Accredited Employer Work Visas, before they need to leave the country for at least 12 months, and there are slightly different timeframes for other roles, before being able to be granted another Accredited Employer Work Visa. The required maximum continuous stay may change depending on someone's role, pay, and when they were granted their first Accredited Employer Work Visa. It's important to note here that nothing is changing for ANSCO that those top tier skill levels, so 1 and 3, paid above the February 2023 median wage. Regarding the maximum continuous stay and the visa duration, right? And we're continuing to go on with some more detail. So the maximum continuous stay is only reducing for those lower skill levels, the ANSCO 4 and 5 skill levels, paid at or above the February 2023 median wage, where the person is not on a green list role, doesn't meet the requirements of that green list role, doesn't earn 1.5 the non-paused February 2024 median wage, or isn't in a sector agreement or care sector workforce agreement role with a pathway to residency. So if a person is in an ANSCO level 4 to 5 role, for example, and doesn't meet one of those exceptions that I just mentioned, it's on your screen there, and they applied for their Accredited Employer Work Visa from 7th of April this year, or before 21st of June 2023, they will only be eligible for a 3-year maximum continuous stay now instead of 5 years. The visa duration for these roles is moving to 2 years at first, with a balance of 1 year being able to be applied for with a new job check, including, of course, testing the labour market. Time is just important to note here, just a little bit at the end. Time on an interim visa does not count towards a maximum continuous stay. Thanks. So we didn't think it was a good use of all of our time to read you out which maximum continuous stay and visa duration applies to every single role, depending on when they apply for their visa. So instead, what we would say is our website contains really fantastic information about this. So it contains numerous tables showing maximum continuous stay and visa duration for each type of role, depending on when they applied. Okay. So these tables cover every possible scenario, and you can use them to check what applies for any particular applicant. So just drawing your attention to that on our website. So we're going to go through some examples that will show or demonstrate some of the things that I just discussed. I know it's a very complex, so bear with me. A reminder that an Accredited Employer Work Visa balance is a new visa application, which equals the length of time someone has left to stay in New Zealand on a new Accredited Employer Work Visa after their current one ends. So the person must meet all applicable requirements for the AEWV when applying for their balance, including new English language and skill requirements. These were introduced on the 7th of April. So I'm going to go through a few examples, and these examples all relate to new applications submitted from 7th of April onwards. But in the later slides, we will cover some examples where the visa application was being submitted earlier. So we'll go through the first one. So example 1, we're going to use a commercial cleaner. So I'm going to use Paul. So Paul is a level 4 commercial cleaner. He's paid above median wage, but does not meet any of the exemptions to be eligible for a 5-year maximum continuous stay and visa. Paul's eligible for an AEWV work visa of 2 years with a further 1 year being able to be applied for on or after the employer has obviously tested the New Zealand labour market. English language and minimum skills, suitably qualified requirements will need to be met when applying for the balance, and the employer needs to engage with work and income and advertise for 21 days. So that's example 1. Example 2. So Hayley is a ANSCO level 4, so that's skill level 4 bulldozer operator. She's paid above median wage and is on the green list. So that role is on the green list, and let's assume that she meets all those requirements. This means that she is eligible for a 5-year maximum continuous stay visa duration. The English language requirements still need to be met, but the minimum skills threshold requirements do not need to be met because the role is on the green list. and they meet the green list requirements. Following this, work and income does not need to be engaged again because the role is on the green list and they meet those requirements. Example 3, we have a tennis coach. So a level 4 tennis coach who is paid 1.5 times the February 24 SMC median wage. This means that they are eligible for a 5-year maximum continuous stay and visa duration. English language requirements still need to be met, and the minimum skills threshold still needs to be met because they are only paid 1.5 times the median wage. If they are paid 2 times the median wage, it wouldn't need to be met. The employer still needs to take steps to ensure that the migrant is suitably qualified, like they wouldn't have to do if they were on the green list, for example, but WINS needs to be engaged because they're only paid 1.5 times the median wage. And example 4. So Pooja is a level 3 veterinary nurse and she's paid at or above the median wage. This means that she is eligible for a 5-year maximum continuous stay and visa duration. English language requirements do not need to be met. That's because she's working at a level 3 role, but the minimum skills threshold and suitably qualified does need to be met, as this applies to all new applications and balances. WINS does not need to be engaged in this example. So just a few examples of numerous cases I'm sure that everyone has out there, but we hope that helps a little bit provide some context. So here, we don't want to linger too long here, but just a slide to draw some further attention to maximum continuous stay and visa duration if someone moves to a skill level 1 to 3 role, for example. If someone has a reduced maximum continuous stay and visa duration, so you can see in the brackets there, a non-exempt skill level 4 to 5 role, paid at or above the median wage, applied before 21st of June 23, on or after 7th of April 24. They can still apply for the balance of their 5-year maximum continuous stay. If they move to a higher skill level role, 1 to 3, paid at or above the median wage. So they're not bound by their original maximum continuous stay if their circumstances change, for example, for the better. For example, they're moving up a skill level. We're going to run through another example for you because scenarios are really fantastic ways of just absorbing the information. So we're going to talk about Di. So Di has a 3-year accredited employer work visa at skill level 4 as a commercial cleaner again, just because this is one we see quite a lot. And that work visa was granted before the 21st of June 2023. He is paid above the median wage. He's nearing the end of his 3-year visa and he's been offered a job at skill level 2. Because he is moving to a skill level 2, so he's moving up slightly in skill level, this means he would be eligible for a 5-year maximum continuous stay and for a further accredited employer work visa for the balance of that 5 years. So he's able to apply for the balance of the 5 years, and a further 2-year accredited employer work visa may be granted if we agree that that role is at skill level 1 to 3. English language in this scenario would not need to be met because the new application is at that skill level 1 to 3. But the minimum skills threshold that the applicant, so demonstrating the applicant is suitably qualified, will apply because this applies for all roles. Thank you. So this is an example of where someone is paid below the median wage and they're moving to being paid above the median wage. So it's important to remember that the 5-year duration and maximum continuous stay for level 1 to 3 roles only applies if the roles are paid at or above the median wage. So the example, so Aria is a level 5 construction worker. She's got a 2-year accredited employer work visa. She's paid below the median wage, as I mentioned, and she's on a sector agreement role as a construction worker. It's an example. So her accredited employer work visa was granted before the 21st of June 2023. 2023. But the date is not relevant here because the person is paid below the median wage. So regardless, Aria would only be eligible for a 2-year visa. Her 2-year visa is nearing its end, and she's received a job offer as a level 3 carpenter. So that's paid above the median wage. This means she's able to apply for the balance of 5 years and would have a 5-year maximum continuous stay. And there is no need for her to leave the country for 12 months. But if she was offered a level 3 carpenter role, paid below the median wage, she would not be able to get any further time on an AEWV because the construction sector agreement maximum continuous stay is 2 years. Thank you. Just moving on here to reusing job tokens. So how does a new maximum continuous stay, how do these changes interact with reusing job tokens? So an example, Amara is a level 4 train examiner. She was granted a 3-year Accredited Employer Work Visa on the 10th of November 2023, meaning her work visa expires 10th of August 2026. Her employer needs her role to continue, and because the AEWV was granted between 21st of June 23 and 6th of April this year, the job token can be reused without the employer needing to do a labour market test. And the new job check, as long as at least the median wage is being paid, because the role is the same and is for the same employer and the same location, so it can be used, right? Because a balance application is like a new AEWV, before Amara can use the reuse token, her employer will send her English language requirements and the minimum skills threshold will still need to be met. All right. So in the interest of time, we won't spend too long on job changes. With job changes, it's relatively more straightforward than some of the other changes. So with job changes, they are not considered to be a new visa application. So the new English language and minimum skills requirements and skills threshold do not need to be met. So when we refer to job change, we refer to the variation, like varying one or more conditions on someone's work visa. It doesn't change the length of it, it just changes maybe their location of work, for example. Just to point to point 3 there on the screen, the maximum continuous stay cannot be reduced by a variation or a job change. Just a quick example, because examples are always really good. So for point 3, an example is that a sales manager, so that's ANSCO skill level 1, with a maximum continuous stay of 5 years, could be granted a job change to a role as an advertising manager. It's also skill level 1. However, a sales manager at ANSCO skill level 1 cannot be granted a job change to a retail supervisor, for example, because that's moving significantly downwards into a skill level 4 role, and it has a very different maximum continuous stay. We're getting there. So just to round off this part, we won't cover all the details here today, so we can just sort of keep to time. We've got a little bit more to cover. They're quite technical, but we want to highlight just a couple things to end this Accredited Employer Work Visa section as just FYIs. So info about 6 roles that can be recognised as higher skill levels. If you would like any further info on this, please let all of us that are here today know. Second point, our website has been updated with our approach for new job tokens expiring before 30th of June 2024. And the last point, for details about sort of other changes, minimum skills threshold, qualified requirements, please see our recent webinars. We've done a lot of recent webinars and our website is updated all the time. So please take a look at those. But now we're on to renewing employer accreditation. So a really, really important part of this morning, and something that we're really cognizant that people have been wanting for a long time, but more information about employer accreditation, or reaccreditation as we're calling it. So yesterday we sent out further communications to industry and sectors regarding reaccreditation if you were signed up to our ProComs, our communications. We thank you for your patience while we worked through these. So as the info has only just come out yesterday afternoon, and I created these slides yesterday afternoon, forgive the state of my next slides. But so just on here, we've got 4 points that I want to quickly draw your attention to. So 4 steps to work through when you're thinking about renewing your accreditation. So decide whether accreditation is required or still required for you and your business. You need to be accredited to hire new migrants on the Accredited Employer Work Visa scheme. Also, for people to apply for the balance of the Accredited Employer Work Visas, and you also may perhaps need to support someone through their residency journey as well. So that's really important to keep in the back of your mind. If you do not want to renew your accreditation, that's absolutely fine. You don't need to do anything. It will just automatically expire on the date it expires. And just coming back to that point about why be accredited. So any migrants you currently employ can work for you for the remaining duration of their visa, even if you choose not to reapply and your accreditation expires. But it's really important, as I said, just to keep in the back of your mind, you'll not be able to support a migrant or someone that's working for you if they want to apply for, say, skilled migrant category, or like a work to residence they're on that work to residence pathway and they come to the residence part of it. So that's really important. If you have any job tokens available as an employer, they will expire if your accreditation expires. So just something there. So point 2, picking the right time. Apply at least 6 weeks before your accreditation expires, and check your immigration online employer dashboard to see when your accreditation will expire. Point 3, choosing the correct accreditation type. This depends on your business, of course, and the number of migrants you hire or want to hire. If you're unsure, please read our guidance and choose carefully. 4th, and finally, gathering the evidence, and this is probably the part that everyone's wanting a lot more information about. So we've just updated our website yesterday afternoon, and I'm going to run through a few things in the next couple of slides, but it was updated yesterday, quite significant updates. And what you'll do is you'll upload this additional evidence as optional evidence or further evidence online when you apply. All right, so I've got 2 more slides, so stay with me. Interim accreditation. We thought we'd just draw your attention to this just briefly because it is important just to keep in the back of our minds. You may qualify for an interim 3-month accreditation if your accreditation expires while you are waiting for the outcome of your renewal, right? Your renewal application. You must have submitted your application prior to your current accreditation expiry. Yeah. So what can you do with an interim accreditation? If you have interim employer accreditation, you can apply for a new job check, which may be very important to you and your business. You may use an existing job token to ask a migrant to apply for an AWV work visa. So both really important things. You must have the right type of interim accreditation for the number and job and type of job that you want to fill. And just importantly here, if the accreditation or the interim accreditation, you are granted is different to the accreditation you have applied for, you must meet the requirements of the interim accreditation. And you can find all of this on our website. I know that I've bombarded you with a lot of information, so much so that I need a little drink. And just something else here that I'd like to point out, we will send you an email. So we'll send you an email 2 weeks before your accreditation expires to remind you that it is expiring. All right. Last slide, very exciting. No, excuse me. All right. Evidential requirements for renewal. For faster application processing. Oh, I'm very sorry. Just been doing a lot of talking. For faster application processing, provide the latest available evidence your business is viable and genuinely operating when you apply to be an accredited employer and when you apply to renew your accreditation. Your evidence should show how you meet one of the following 4 requirements to be considered viable and genuinely operating. And I'll run through those 4 options now. So your business has not made a loss before depreciation and tax over the last 24 months. Your business has had a positive cash flow for each month in the last 6 months. Your business has sufficient capital or external investment to ensure the business remains viable and ongoing. Your business has a credible plan for at least the next 2 years, showing how you plan to remain viable and ongoing. So, next, you do not need to provide evidence your business is viable and genuinely operating if you are, for example, a Crown entity or a New Zealand government department, and there are a number of other ways you can meet that. It's all on our website. As I said, we had a lot of information released yesterday afternoon, so please take time to read that. Evidence showing the Employment New Zealand modules have been completed, and this is another area that people are really keen to get more information about. If your business has less than 5 people making recruitment decisions about an AEWV holder or applicant, you must provide all the employer module completion certificates for each of these 5 people. If your business has more than 5 people making these decisions, your evidence should show completion certificates for at least 5 of these people, and just a total number of people that may be making these recruitment decisions. Oh, I'm really struggling here. I'm coming to the end. Evidence of settlement support. Examples, right. So examples of evidence settlement support include, but are in no way limited to, copies of any documents, any information you gave your employee to help them settle in New Zealand. So that might look like letters to the employee, emails. It may look like invoices from relocation specialists, training courses, copies of onboarding, induction policies, evidence that you gave your employees time to do those modules. It's not limited to that, but those are just some examples for you. And that's it from me. And apologies for all the coughing at the end. I'll turn my mic off. Thank you.
Excellent. Thanks, Lauren. And, there's a lot of detail in there and a lot of detail behind the scenes. So, and we're going to cover some of that shortly with some Q&A and some of the questions and things. But what we're going to do now is move on, and Sylvie from MyHR is going to step us through some the HR and employment law side of things. So welcome, Sylvie. Over to you.
Kia ora, Ellen. Thank you. Kia ora koutou. Lovely to see you all. My name's Sylvie. As Ellen mentioned earlier, I'm the Chief Evangelist for MyHR. And thanks to Lauren for being a total trooper and pushing through a bit of frog in the throat experience there just before. So I'm just going to pull my screen up and share some slides. I've got 10 minutes today to work through, and I just spent 27 seconds introducing myself, so apologies in advance for the pace of content as we blast through here. So the first thing we'll talk about today are some fundamentals around managing your employees. We'll skip ahead to paying them and what you need to be aware of. We'll talk about recording time and attendance, look at policy and internal documents, and finish up with some specific tips for managing employees on visas. So in terms of the fundamentals, when it comes to employee documents, the most critical thing is that all of your employees, whether they're permanent, fixed term, or casual, must have an employment agreement in writing signed by both parties. The compulsory clauses that you must have in your employment agreements are the names of the parties, a description of the work to be performed, typically a job description, the place of work, their agreed hours, how much they will be paid. You must state that they will be paid time and a half for working on a public holiday that is an otherwise ordinary working day for them. A plain language explanation of how to resolve employment relations problems, and an employee protection provision if it's applicable, as well as the nature of employment, whether it's permanent, fixed term, or casual. Be aware that there is a $1,000 fine on the line if you don't have a signed employment agreement. It's really easy to have in place. And of course, if you have an employee on a visa, it's a part of the process for you anyway. But be aware that this applies to all of your workers, whether they are on visas or not. So when it comes to paying your staff, this is the foundational requirement of an employment relationship, right? I love my job, but if I wasn't getting paid, I probably wouldn't show up. So we need to be making sure that we're paying and remunerating our staff for the work that they're performing as a key requirement here. Interestingly, the law defaults to employees being paid in cash, which is absolutely a hangover from the 20th century. I don't know very many people who get paid in cash these days, but you do need to specify how you will be paying them in the employment agreement if you don't plan on paying them in cash. So these days, 99% of the time, it's a bank transfer, but you do need to now specify that there's a bank account you'll be paying into if you aren't paying them in cash. Make sure you're paying them for hours worked in each pay period. And also the minimum wage must be met in each pay period. Again, this is typically a concern, not of employees on visas because of the earnings requirements. But if you have someone who is earning, let's say, $10 an hour as their retainer, but gets massive commission payments that are paid at the end of each month, but if they're being paid weekly for their retainer payments, you're actually not meeting minimum wage in each of those weekly pay periods. You're going to have to look at smoothing your payments to make sure that you're meeting minimum wage for each of those weeks that you're paying. Jumping through to time and attendance. In terms of what you need to record, you must keep accurate time and attendance records for 6 years. That's the employment law requirement. You need to keep pay records for 7. That's the tax and IRD requirement. So most of the time, that means that employers will keep records of all time and attendance for the 7 years, just because it's easier to kind of bundle it all together. This is a requirement of the Holidays Act and the Employment Relations Act. This is a legislative requirement. It's not just me as an HR person wanting to keep files tidy. I promise you there is a legislative requirement here. This includes all hours worked and paid, breaks taken, leave given, what they've been earning, the tax, the KiwiSaver, all of those pieces for that period of time. And this means that 6 years is also the maximum amount of time that you can be required to revisit if a labour inspector or if the Employment Relations Authority thinks that there's been a consistent systemic breach of any of your obligations under either of those pieces of law, and you need to go back and recalculate annual leave or recalculate sick leave for your employees over that period of time. We're doing awesome for time. Good job, us. Thanks for coming along with me. So when it comes to policy and internal documents, policies are really about managing your obligations and requirements towards your team and making sure that everyone is on the same page. Too little policy means there's probably going to be some areas of the business which are unclear and maybe you're not documenting as much as you could be here. Too much policy means that no one's looking at most of it, let's be honest, and you've probably got obligations and processes that you're actually not following, which can cause headaches down the line. So make sure you're creating and using policies that have a purpose. Don't have a 120-page health and safety handbook if there's 5 of you sitting in an office somewhere. That's probably not necessary. So make sure it's fit for purpose and make sure it's not onerous or otherwise too light. Make sure you keep signed records. So when we have policies in place, and if you ever do need to enforce or run a disciplinary process for someone failing to follow policy, if you've got a code of conduct which talks about how they have to conduct themselves at work and you need to hold someone accountable, showing that your employee has read and signed the document obviously is really critical. If it's in place but no one's looking at it or you don't have a signed record, it's unlikely you would be able to use that to manage any situations that arose in your business. And lastly, but most importantly, please do what the policy says. If there are commitments that you make in there, let's say around how you would handle an employee's complaint about harassment or about the colleague of their the behaviour of their colleague who they just think is a massive dickhead and just want to have a bit of a whinge about. If there are processes or things that you've committed to there and you don't follow them, you're failing to meet your good faith obligations and failing to meet the obligations that you've set down in writing. So if there's anything in your policy suite that you're not using, think about whether you want to remove that or whether it still has value. And when you do come to manage an employment situation which requires a bit of care and attention, the first thing to do is go to the employment agreement. The second thing to do is to go to your policies and make sure that you're doing what you said you would do. Second to last piece here, so employees on visas. What's particular about these workers that you need to know? So as well as all of the points that we've run through so far, the first thing to note here is that you need to keep a copy of the visa on file. This is important for a bunch of reasons, but mostly it acts as a reference point later so that when you're making changes, or if their manager has left and a new manager has come in and is trying to manage a situation with them, you've got an accurate record of all of their documents on file. I would also strongly recommend including a clause in their employment agreement which relates to what happens if their visa ends or what happens if it's not renewed. This can be as simple as a clause titled work visa and then stating what happens. But if you don't have anything in the employment agreement about how you would handle things if their employment did end, you run the risk of not being able to take steps to action that or to respond as you might want to if the visa doesn't get renewed or if you choose not to support their application again. This one seems really obvious and I thought it might be trite to include, but know the conditions of their visa. This is important because when it comes to managing change, you're going to need to manage that change within the conditions of their visa. So if you, as the business owner or manager, if you're aware that some of your staff are on visas or working visas, when you do have new managers come through, take time to acquaint them with the members of their staff who do have these visas and these conditions in place, because it will make it a lot easier to manage any change or differences when you get there. Know the end date, that's an obvious one. Set a reminder 6 months out from expiry of the end date so that you've got time to consider whether you want to apply and you've got time to meet all the tests necessary to get the visa extended. Pay the appropriate rates. Of course, please don't say that you'll pay someone twice the median wage and then not pay them that. That's a really critical one. And if their employment ends, let Immigration New Zealand know. And lastly, do seek professional advice if your circumstances change. On the employment relations side of things, this would be having a conversation with your consultant, your professional, MyHR if you're a client of ours, about managing the consultation process if something does need to change, whether it's their hours, their pay, their job. On the immigration side of things, again, if there are those changes that you're looking to make or in the process of kicking off consultation for, get immigration advice and speak to New Zealand Shores to make sure that you're not missing a trick in terms of your obligations towards these employees. So what's unusual about MyHR is that not only do we have HR people like me in the background who are here as your HR advisors and HR support, we also have a platform that we've built in-house. We're a New Zealand owned and operated business, which is your one-stop shop for HR truth in your business, as well as being your platform to integrate with payroll, with your applicant tracking systems, and of course, managing all of your HR processes to do with onboarding, e-signing of policies, performance reviews, document storage, all of that kind of stuff. So if you're interested in having a look at our platform and the support that we can provide, we've got a short demo that you can click through. You don't have to talk to anyone. We're not going to call you and harangue you afterwards. So jump online, have a click through and see what the different tools are that we have. It'll look like this. You've got a couple of different tour options you can take to see what the document storage looks like, what the HR support looks like, and what some of the processes are. And if that's of interest to you, you're very welcome to get in touch and book a demo for us to have a conversation going forward. With 1,300 businesses around New Zealand and Australia that we support, we're pretty confident that we can add value in most circumstances. So again, get in touch if this is something of interest. And at 9 minutes and 45 seconds, I have come in under time. So thank you everyone for your attention, and I will hand back to Alan to continue the session today.
Amazing. Excellent, Sylvie. Yeah, I must say that, look, yeah, do look into the MyHR model. It's a really good value for service and very well priced. It's so I must say that got a great business model there. Thank you, Sylvie. Now moving into the next step, we are going through some Q&A, and a lot of this has been captured over the last few months, really, and we see a lot of this stuff coming through from employers. And a lot of the theme of it is really as employers wanting to provide some certainty of their to their workforce and also obviously their business flow. And a lot of the employees that are on temporary work visas are in an uncertain space, don't quite know what their pathways to residence are with these changes, and they don't know what the duration of their temporary work visa may be. So it's really important to flesh that out and give your staff the confidence as to what that means to them. So we've sort of unpicked a few of these things. Some of these questions are going back to immigration. And so we'll have Paul and Lauren answer some of these questions, and then we'll have some questions answered by Charlotte and Fabian. So now I'm going to hand over to you guys.
Awesome. Hi, everyone. So our first few questions are directed to Immigration New Zealand. So Lauren and Paul, you guys are up. Our first question is, if an employer has not renewed their accreditation and has an employee who has a visa for 3 years and needs to apply for the further 2 years for the new 5-year entitlement, will there be any impact on said employee being able to apply for the additional 2 years when the employer is no longer accredited?
Yes, and the answer is yes, there is an impact. If the employer hasn't renewed their accreditation, the employee will not be able to apply for the further 2 years of the balance they're trying to get. The employer needs to hold valid accreditation at the time that an AEWV application has been made.
Okay, so there's probably people on here who aren't aware, but an employer doesn't have to renew their accreditation if they don't want to. They can still retain their staff on their AEWV, but if those staff then want to go and obtain an extension, so they do have to then become reaccredited at that point. So that's really good to know, actually. Thanks, Paul. Moving on to our next one. What is the interim process for accreditation? So some people will have accreditations that expire and they submit their reaccreditation applications, and obviously those will take some time to process. So what happens in the interim while they're waiting for that? Are they still able to submit job checks, hire new staff? What does that look like for employers at the moment?
Yeah, interim accreditation means that they retain the right to continue to support work visas and to use tokens. Obviously, interim accreditation doesn't apply to everybody, so Lauren just covered a bunch of information about the new changes. So if you're having to apply for a different type of accreditation from the one that you currently or you initially held, you won't get interim accreditation, but if you do receive interim accreditation, you will be able to retain the rights of supporting work visas and job checks applications.
Okay, perfect. So if you're, I guess a good example, if you've got standard accreditation at the moment and you're applying for a renewal of, further standard accreditation, you'd get interim accreditation. But if you've got standard accreditation and you're perhaps under your renewal process, then going for a high volume accreditation, that interim accreditation doesn't apply. Is that correct? Yeah, okay, I'm getting some nods. Perfect. All right, we'll pop on to our next one. What happens to a migrant's pathway to residence if their employer's accreditation is not renewed before they make their residence application? So I guess perhaps if the employer's submitted their accreditation and they've got interim accreditation, can they still submit a residence application?
Yes, they can. So under the new pathways to residence, the skilled migrant category, straight to residence and work to residence categories, an employer must be accredited, but they can't be suspended and they can't be revoked at the time that the residence application is made or decided. So if a person has lodged their application for residence, the employer must be accredited at that point in time to be able to support that residence application. Lauren might have a couple of thoughts on that.
The only thing I would add is, they just have to be accredited at the time the decision is made, like what Paul just said. Yeah.
Okay, cool, perfect. So sorry, I'm just drilling into this a bit deeper. So someone submitted their residence application, the employer holds interim accreditation perhaps at the time that was submitted. They'd have to wait for the new accreditation to be approved before the residence application could be approved. Is that what you're saying?
It depends. I can take this one, Paul. It depends. I'm not, in terms of the processing officer's approach to, like, would they send a PPI? Would they send, a request for further information? Would they hold the application awaiting that new accreditation? I couldn't comment, but I can definitely come back to the group on that. But I know that the employer has to be accredited at the time the decision is made. So I guess it would be quite detrimental to the application and slow it down very considerably if the renewal, for example, of accreditation took a significant amount of time.
Okay, cool. Thank you. I realize we're getting into the nitty-gritty there a little bit. Awesome. So moving on to the next one. Awesome. So will Adept expire any remaining available tokens as soon as the accreditation is expired, or is their employer still potentially able to send available tokens to clients?
In cases where the employer chooses not to renew their accreditation, but they still have tokens available beyond the expiry date of the accreditation, the employer won't be able to send those job tokens to potential employees. When an employer's accreditation expires and there's no new accreditation or reaccreditation application submitted, all existing job checks will expire and customers will no longer be able to use the tokens. So the answer is no, if they've not applied and for a new accreditation, so they will not be able to use those tokens.
Okay, cool. Thank you. That's pretty self-explanatory there, isn't it? Moving on to the next one. Does an employer whose accreditation expired but has not applied for reaccreditation still have access to their My Dashboard in Adept to view submitted applications and issued visas?
Yeah, and the answer is yes. Really
Okay.
simple. They'll still be able to view the information.
Okay, perfect. Easy. So last one for you guys at immigration. The maximum stay on an AEWV is 5 years. What happens to AEWV holders who have a pathway to residency but need more time to meet residency requirements?
Yeah, that's a great question, and one we've raised with our policy people in Wellington over the last week or so. There is an answer coming for exemptions to the maximum continuous stay for people that have a pathway to residence. So watch the space. There's information that will be coming out soon, and the folk at New Zealand Shores will be getting that information as soon as it comes to hand.
Awesome. We're looking forward to that because we're getting a lot of questions coming our way on that one. So be good to get that update. Awesome. Thanks heaps, guys. Our next question will actually be for Alan. So obviously, as a company, New Zealand Shores has done possibly thousands of job checks in the last couple of years. What are the most common mistakes you're seeing when employers do the job check applications themselves that are potentially causing declines or slowing down approvals?
Yeah, there's a few, tips and tricks, or a lot actually. I'll just quickly run through some things. I mean, suitable platform is a key one, but most often when you're advertising, obviously the suitable platform, but the hourly rates are often missed, or they might have a stating the minimum and maximum, and ideally having that minimum at the median wage or higher is a big one. A lot of people advertise and for rightly don't actually put those rates in, because quite often it's higher than what they may be paying others for that same role. So that is a really key INZ requirement, to have that on the advertising in at least 14 days. Other ones capturing the applicants and knowing whether they're New Zealanders, citizens or residents, and seeing whether they're suitably qualified for that, and having some criteria around why they've been ruled out for that position. So capturing those numbers is really important. Other ones within the job checks are the templates you use for employment agreements. Quite often the employment agreements sometimes they may even have applicants' names in them, which the job check has to be templates and that you're submitting. It may have within the hourly rates, again, you may have minimum hours per week has to be 30 or more as a full-time role, but it may not have a maximum. In the employment agreement, it may even ask that you are looking that they may have to work more than those hours, and they may not stipulate overtime and things like that. So immigration, when they calculate the hourly rate, is based on several factors, but it's basically the minimum rate versus the maximum hours, and that's going to have to be more than the median wage. So need to sort of look at all those tips and tricks and make sure they're baked in there. And travel expenses, if they're expected to travel, they're going to be covered by the employer. So what else have we got there? There's a whole bunch of them. If it's green list, a lot of people are selecting green list in the job checks, and the applicants then in the work visa have to meet that criteria. So and then they can't use their job token if the candidate doesn't meet green list. They have to go back, re-advertise, redo a job check, etc., and delays matters. So getting that advertising right, getting the job check right, and understanding the candidates that are applying. Yeah, so anyway, that's a quick brain dump of it.
There's definitely a few things you have to look out for to make sure it's approved quickly and done right the first time, that's for sure. Cool, popping on to our next question. So this one is also for Ellen. Is there a list of documents required to remain compliant for accreditation/reaccreditation?
There's a bunch of things to look out for, and some of the key ones, I guess, is that you're distributing the settlement plan to your staff, that they're on temporary work visas, that they're doing the employment modules, and that's for your migrant workers within the first month and doing it during paid work time. Also looking at your managers and hiring managers, and also the direct line managers are actually doing their employment modules as well. And then obviously everything in accordance with the work visa. So yeah, those are the key ones, key outtakes there. We do provide the settlement plan, compliance plan, and a breakdown in more detail as far as everything to read through and try and keep those and file them away. And Immigration New Zealand are actually doing spot checks, and we've had a number of our clients that have been immigration have actually turned up at their offices in person and interviewing them and their employees. So it is happening, and so we do suggest that you do capture and save all these records and have it tidied away.
Awesome, cool. And popping on the next one. So you did just touch on this a little bit there with settlement guides. So accreditation does require that employers provide their migrant staff with some settlements assistance, upon arrival. Are there specific guidelines on this, and how can New Zealand Shores help employers meet those requirements?
Fabian, would you like to answer that one?
Yeah, sure. So there are definitely some guidelines on this that immigration has circulated on numerous occasions. But New Zealand Shores can add value by providing a white labeled settlement plan that certainly covers everything that immigration requires and more, perhaps more on the practical side as well. But things that are mandatory include assisting your newly arrived migrant staff with finding suitable accommodation, RD tax numbers, opening a bank account, things like this. All of this we can advise very accurately on it.
Cool, perfect. And then our last question that we have goes to Sylvie, actually. So I think there's a lot of confusion often from employers that aren't familiar with immigration about things like sponsorship, does it exist in this sense, etc. And they often ask, is there a difference between what I have to offer migrant staff versus what I have to offer New Zealanders? So in particular, do employment agreements have to differ for migrant staff versus New Zealanders?
Yeah, excellent question. It depends on the conditions of the visa, but broadly your employment agreement will be the same. So again, those compulsory clauses around outlining what the pay rate is going to be, what the location is, what the work is to be performed. So the job description will all be very similar and will meet those requirements for Immigration New Zealand. Again, that other piece I would just flag as a clause stating what happens if the work visa expires or doesn't continue. And sometimes in the offer letter that accompanies an employment agreement, there might be particular wording immigration is looking for around the circumstances of the visa, but broadly they're very much the same.
Awesome, thank you. Wonderful. I'll hand back to Ellen. I'm not sure if we've had some questions come through on the Q&A or not, but I'll hand back to Ellen to wrap up.
Yeah, we've got some fantastic questions there, but I'm going to hand over to Fabian. He's going to just take us through basically a summary and a recap just in the last 2 minutes. And yeah, so Fabian, over to you.
Awesome, thank you. Thanks everyone. Thanks Lauren, Paul, for the in-depth presentation of the recent changes. Thank you, Sylvie, a lot for your insights into employment matters. We're running out of time, so I'm just going to quickly consolidate everything that we've seen. I'm sure it's been very useful to the audience, and we certainly appreciate your time in picking all of this for us. Clearly, what we've seen is an emphasis on compliance requirements with, additional checks being done by immigration, as we've seen over the last few months. These impact job checks, employment matters, but also English requirements for your staff. Just quickly brushing over compliance matters. In terms of compliance, the updated requirements certainly have an impact on reaccreditation applications coming up for the majority of accredited employers in 2024. So what this means is you need to make sure your company records and employee records are in order. whether pay slips, hours done, overtime, etc. Make sure you've provided settlement support information to your staff, allow time during work hours for them to complete the employment modules, that sort of thing. One major change we've seen is now the obligation for an employer to notify ANZ when a work visa holder finishes employment, whether on their own will or gets dismissed. This is now mandatory if there's less than a month left on the work visa holder's visa. And as a matter of fact, it has become a compliance requirement. So your reaccreditation may be declined if you fail to notify immigration. And I think we've seen is a much stronger reliance on ANZCO. It almost feels like we're back in time there at the time of essential skills, which some of you might recall. Much stronger emphasis on ANZCO, as we're saying. More of a technical challenge for some employers who may not be familiar with the classification of occupation. For some of them, it's familiar. For others, it might still be a bit obscure. But yet, getting things right with ANZCO is absolutely vital because it impacts advertising requirements, the labour market test and how you approach it, and also the visa duration for your migrant workers. So as we've seen through, immigration presentation, absolutely no changes for skill level 1, 2, 3 occupations, but major ones for skill level 4 and 5. Just to name a few, advertising for 3 weeks instead of 2, and the obligation to engage with Work and Income New Zealand in most cases. Also an impact on the duration of accredited employer work visas. It has gotten quite a bit complex to determine how long a staff can get a visa for, because it is a combination of the skill level in ANZCO, the salary or hourly rate offered, whether the role is on the green list, and if the requirements are met, and when the visa was applied for. But ultimately, as an employer, what this means is you need to ask yourself, how long can I keep that person on board? And does my staff have a pathway to residency? So New Zealand Laws happy to offer a free evaluation of your staff's current situation and prospects, so you can have certainty of keeping them long term. It's about the viability of your business and your workforce ultimately. Another major change is the mandating of English requirements for work visas. New Zealand Laws actually partnered with IELTS New Zealand. So get in touch with us and we can recommend the nearest test center for your staff. You need to keep in mind that it's not only for new recruits, it's also for your current staff needing to extend their visas, or if you want to bring someone over from another company, for example, and they need to apply for a new visa. So this is an important change. As a side note, partners and dependent children are unaffected by English requirement changes for work visa purposes. What's the outlook for 2024? Well, I think the key for employers throughout the rest of the year is to be mindful of the steps you need to take, not only to hire migrant workers, but also to retain your workforce. So this means being proactive more than ever, knowing and working on your compliance paperwork, whether with New Zealand Laws and MyHR, for example. Planning ahead for new recruits, the importance of planning more critical than it ever has been, because those processes take time. You need to keep in mind the steps required and immigration processing times. So important to get things right the work time, to get things right the first time, work with us, plan your workforce requirement, your advertising requirements for the rest of the year. And as always, New Zealand Laws available for any questions you may have. So yeah, feel free to get in touch.
Fantastic. Hey, thanks everyone. That has been, I mean, I'm hoping that's added a lot of value to everyone that's dialed in, and certainly appreciate, and thanks once again to Paul and Lauren, and also to Sylvie. It's always appreciated, particularly a lot of the support that you help with us behind the scenes that as well. So thanks for your time. Thanks everyone for dialing in, and yeah, please reach out and we'll see how we can help in the future.